As a debt collection agent in South Africa, encountering excuses on a daily basis is just part of the job. At ICAN, we have identified the top 10 excuses given by South African debtors and have highlighted some of the remedies that may be available to the debtor and credit provider, or lender as you may prefer. In today's session, we will focus on the most extreme way to enforce repayment from a debtor, and this will be through a court judgment. And this remedy is available to credit providers in South Africa under the Magistrates Courts Act. During this session, we will guide you on how to effectively deal with this excuse, as it may be a sign that the debtor is simply avoiding repaying of their debt. My name is CraigANel. At ICAN, we love our quotations. And one of our popular ones is by Abu Bakr. Without knowledge, action is useless, and knowledge without action is futile. We spend a lot of time developing these courses and try to test it in multiple contact centers across the country and in fact in Africa. So we strongly suggest that you implement the tools that we provide you in these courses and reach out to us as well if you would like more customized solutions to be designed for your business. The learning outcomes is quite simple. It's basically understanding how to deal with legal remedies available to lenders. And what we mean by that is debtors will likely use the excuse to say that they will not make an arrangement with you if you are a credit provider or other lenders are currently engaging with them or they have initiated the legal collections process. And for this reason, we'll provide you with the guidelines and how to deal with those excuses. The Magistrates Courts Act provide very clear guidelines on the processes and steps that need to be followed by credit providers. One of the key things is there have to be some sort of notification in writing. Now in South Africa, even though it's not a proper legal document, some companies send a letter of demand where they request a repayment or settlement within a certain periods between 7 to 14 days. And most credit grantors will send what is guided by the National Credit Act, a Section 129 notice. And what it basically is just a kind of standard letter that guides, that informs the debtor of the creditor's rights and also what options the debtor might have, which includes going for debt counseling and so forth. And in that letter, they would also demand that settlement takes place. So this is important for you as a collector to understand, to become familiar with these documents if your company does use it, and understand the wording therein, because you can obviously in your inquiry or engagement with the debtor, you could ask them, have you received this notification? When did you receive the notification? Excuse me. And once this is complied with, then the creditor can proceed with the process according to the Magistrates Court Act. And in fact, we've learned that even in the formal documentation, when credit grantors go to court, they will actually attach a copy of either one of these notifications, which is either the letter of demand or the Section 129 notification. In some instances, if the debtor really cannot afford the repayment according to the short deadline that's been given through the notices, they can agree to sign an acknowledgement of debt. However, if they fail to pay and have signed an acknowledgement of debt, the attorneys will have a much speedier way of getting the legal process activated. Because in that document, and as we'll discuss later, you're basically acknowledging that you owe the money, so there's no dispute around that. you're consenting to quite a few things, even jurisdiction. So you're just making it, if you were debtor, much easier for the credit grantor to execute and to exercise their right by using this remedy. An acknowledgement of debt is a very, very effective tool, and it's good. It's used considerably by some credit providers, and I think the key thing is that debtors need to understand that it's in essence a legal document that can be forced and could, as mentioned earlier, and could speed up the journey towards getting a judgment much quicker. But basically, they acknowledge that they owe the debt, and they also confirm that they have no valid defense. So we acknowledge it, sign it, and so forth and so on. In there, they would also often agree that they'll cover the legal cost, and the debtor would also choose the address on which they acknowledge the debt, as in which if any further documents need to be served by a sheriff, they would agree on the address, so there's no dispute. And these things are often the issues in the legal process that becomes a question of dispute and debate and delays the granting of the court order. So the AOD is I would say, quite an efficient way to for the debtor to understand that you are serious as if you're a credit provider, and B, it's to enforce to get some action as quick as possible, considering the constraints experienced in South Africa with the legal system. And in essence, this means that a summons can be affixed to the resident's door by a sheriff, so it doesn't have to be given to them physically. And this helps a lot, especially in South Africa. Many people will live in complexes and have to go through security and will not be given access and so forth. So this can be quite popular, but bearing in mind, quite expensive. I think the ultimate question is, how is this relevant to you as an agent? It is important. We always talk about being a smart agent is to understand, have you received a letter of demand or a section 129 letter or notification? How far are you in the legal process? Have you signed an acknowledgement of debt? And if that's the case, then that's a good thing for the client. If you are a debt collection agency, and also, so obviously that's important. And and I think to the next point is whether you have a summons. And if there's a summons involved, you can then obviously ask them what the case number is and so forth and so on. So this is a way to kind of assess whether the debtor is actually sincere with regard to this excuse that they're not paying because they're already in a process with a client, or there's especially if you're an external debt collection agent. If you're working for a company that's the lender, well, it will be much easier because you would know that the debt is outsourced already to an attorney to follow this process. So yeah, this is quite a nice, simple, summarized way to explain the lengthy process. So there's a demand is sent by a letter if they refuse to comply with the demand, and often it is the settlement of the total due. And I urge you as collection agents, often when you do make calls and a debtor owes a certain amount, you always go to the lowest amount. Now, if the company that you're working for pursues the legal collections process, we strongly urge that you align with that and demand, especially in the early stages, demand settlement of the total arrears. And that will benefit you, it benefits the debtor, and most importantly, the company as a whole. If the debtor fails to pay, the attorneys will likely proceed with summons. And summons is also dependent on the courts and the capacity and volumes, and summons are served by sheriffs. And if the summons is served successfully, there will be a court date for the debtor to appear, and they'll be given an opportunity to defend themselves. And there are various provisions in the Act which will enable the credit provider debtor to engage And even there's an opportunity for the to do a financial review. I think it's through one of the provisions in the Act, but that's not necessarily important for the purpose of the course today. What is important to note, if the credit provider is successful in getting a judgment, they will be entitled to enforce that judgment for 30 years. And what that means basically is it may mean that at the time of getting the judgment, the debtor was unable to settle, maybe they're unemployed, or whatever the financial situation is, but they'll be able to enforce the judgment for a 30-year period. So this is quite hefty, and I think it's important to notify the debtor if they're going this route. This is a long, very, very expensive route to go, and more importantly, obviously this will appear on their credit record, and credit bureaus in South Africa can only retain this the fact that there is a judgment for 5 years. After the 5 years, the judgment is not removed. It's just the fact that it won't reflect on the credit bureau. So just be mindful of that. Again, understand what we're trying to do with this training. We're trying to give you an in-depth and also high-level overview of the process, so that in the event of the debtor raising this as an excuse, you are able to fend for yourself. So let's, for argument's sake, say that the court decided in favor of the lender or credit provider. There are further mechanisms available to them in the event of the debtor not complying to repay the debt or make some sort of payment arrangement. So there's the warrant of execution, which is an order which is taken against the debtor, where the credit provider could then sell the movable assets. And this process will be driven by the sheriff. It's quite a involved process, and as you can imagine, it will involve the sheriff going to the debtor's house, writing up a certain amount of the goods, and it should be to the value of the debt that's owed. And the debtor will be given opportunity to settle that arrears or the amount that's in the judgment, failing which the sheriff will come along with his mates and collect the goods, and then have it auctioned off, at which point, if they've sold adequately to the point where the debtor settled, they will also, if there's any surplus money available, obviously all their costs needs to be defrayed against that. So again, more costs. It is an expensive, and in this case, an embarrassing situation for the debtor. Not many companies go this route, but it's an effective tool. Often when the sheriff arrives with a warrant of execution, many people would rather settle. I like this tool, and I think it should be used more by more and more credit providers, but that's just my view. If the movable property is insufficient to cover the debt, the credit providers can still go for 65 financial inquiry. And when this is where the debtor is called to court. Now, please come and explain your financial situation. You don't have enough movable assets to settle the debt. And this is now kind of where the rubber meets the road. So the process doesn't end, and this is when our old remedy that caused lots of controversial issues in the past, the emolument detention order, which is basically the court instructing the debtor's employer to pay a portion of the debt until it's settled. So this is, again, the right of credit providers are significant. And debtors that want to dabble in this area and claim that they're going through the process, I think it's important for you as a collector to inform them, and also to display that you have significant knowledge of the process. And I think just beware. This is an expensive process, and it can be quite damning to the debtor. And again, as you can see, they'll go after the investments, whatever money is available, whatever kind of assets they can liquidate, the credit provider will go after it. And yes, so I think the key thing for you as a collection agent is to just become familiar with the processes, the steps, the mechanisms, the tools that's available, and most importantly is to ask the debtor, what stage are you in, what phase are you in. So this could be a way to figure out if they are fibbing, and often they are. Your preparation, as always, is key. And often, if it is that you're an external debt collection agent, it's highly unlikely, unless you are the attorney acting on behalf of the client, that they will just outsource it to anyone. As we've mentioned earlier on, it's very expensive, it's quite involved, there's a massive paper trail that goes with this, so it's highly unlikely if you're just a debt collection agent that it would be outsourced to you. However, if you have the ability to proceed with the legal action, then in that instance it will be handed over to your company. Do not accept any excuses, especially even your collection agent. They'll say, yeah, but the client has started the process and I've received the summons and there aren't any excuses until that point where they got a court order against them. So just be vigilant, ask the right questions, and be firm and be fair, but also be empathetic, considering the fact that it is a costly and in some instances quite a humiliating experience for debtors. And as you know, we always end up with some tips, the standard tips now that you hopefully will become familiar with. Always thank the debtor, be courteous, thank them for sharing that they're going through whichever process they are, either a process that benefits them, or the fact that in this instance, the credit providers initiated legal collections. Continue with negotiations. And I think the key thing for you is, often when debtors use these legal terminologies, you'll start putting it in an admin process. No. This is where, just inquire, ask what stage they're in, have they received the summons. Obviously, you know your business if you're an external debt collector, if your company offers that service, but just be firm and fair. But also, I think in summary and in conclusion, educating the debtor is as powerful as getting a payment arrangement. I think it's even more powerful, because often the debtors would choose paying you over everyone else, purely because of your empathy, and number two, you've educated them, and it allows them to make informed decisions when they do have access to cash. This was a pleasure for me to engage with you, and thank you for watching the video. We encourage you to ask questions. You can communicate through all the channels that will communicate with you just now after this video, or speak to your company or supervisor to engage with ICAN so that we can develop a customized solution for you. My name is CraigANel.